go ahead and get started. Thanks for joining us this afternoon. Today we're going to cover the New York State Department of Financial Services Cybersecurity Requirements Overview. And you can, if you're looking for a copy of the regulation, if you do a Google search on the regulation number that's below it on the title slide, you can find a copy of that. Or if you'd like afterwards, you can reach out and we'll send you a copy. So the agenda for today, we'll talk a little bit about the regulation background, kind of the timing on when it came into being. We'll talk about specifically the limited exemption qualifications, which we've gotten a lot of questions on. We'll talk about the phase requirements and key dates that you need to be aware of. And then last but not least, we will also give some practical application tips based on activities we already have underway relative to complying with this regulation. So as we go through, if you have any questions, please feel free to use the chat function, and I will try and answer them as they come in. Or you can wait till the end. We'll have a Q&A period at the end as well. So with that, we'll go ahead and jump right in. So DFS in mid-February of actually 2017 came out with a regulation that they had actually put out as a draft a couple of times late last year, mid to late last year. And so I think it was a little bit of a surprise to folks that it was released so quickly. It has an effective date of March 1st that's already passed, so we're about 6 weeks, 7 weeks past that. And what it really seeks to do is establish a minimum standards for protection of consumers' private information, as well as establishment of the cybersecurity program. And that's really kind of the key sort of component or overarching piece of this piece of legislation. Some of the drivers, if you've heard the superintendent speak at any conferences or read any of the news articles or materials that they put out on kind of what's driving this, it's also included in the beginning language of the regulation itself. Is they did a survey back in 2015 of I think it was about 40 different financial service firms, just to try and get a lay of the land of what those firms were facing. And based on that assessment, that survey, as well as collecting information from other areas of the country and other financial service firm breaches, they came up with what they're considering sort of drivers for the regulation. So no surprise, the hackers are increasingly targeting both information and financial systems, and those are terms that are used throughout the regulation. And then they're also seeing a mix from a threat actor perspective. So these are the folks that are actually perpetrating the attacks. And you can see, and these are the ones that they specifically cite in the regulation. So nation states, interesting that you're seeing that, but if you look at financial service, just the industry from a critical infrastructure perspective, clearly it has a very big role in our economy and is very important to protect. Terrorist organizations for really the same kind of motivators or drivers as those nation states. And then also independent, kind of the catch-all is the independent criminal actors. And so these are not the only threat actors, I'm sure, that are targeting financial service firms, but these are the three that they cited as the most common, and also probably the ones that they're most concerned about, primarily from a sophistication and kind of capability standpoint. So some additional information on the regulation kind of background. So what they're really looking for, what they're requiring DFS is that they want to ensure that all of the covered entities that fall under their purview, under their scope of enforcement and regulation, that they implement and maintain what they call a cybersecurity program. And so the couple key points there, they're not just looking for you to basically stand up a program and then they kind of walk away. They're really looking for you to both implement it if you don't have one in place already, and then really for the foreseeable future, maintain and kind of enhance and evolve and mature that cybersecurity program. Just some key points that are specified in the regulation, and probably the one that I think caused the most senior executives and board members to really grab their attention is this regulation requires an annual compliance statement from the board of directors, or if you don't have a board of directors, from the senior-most officer within the company. And so that statement is due, the first time that statement's due is February of 2018, which will be here before you know it. And we'll go through the dates in a later slide. Again, as I mentioned earlier, really what they're looking for you to do is to develop and implement a cybersecurity program, but not a generic one. I mean, they definitely give very specifics, requirements on components of a traditional cybersecurity program that you're expected to have, depending on your size. So an example would be vulnerability scanning and pen testing, incident response planning, those types of things, which are pretty common. But really what they want you to do, and really require you to do, is do what's called a risk assessment, an organization-specific one, and use that risk assessment to then drive the development and ultimately the implementation and maintenance of your cybersecurity program. Another kind of a key piece, which I think people were surprised wound up making it into the final version of the law, is that they are requiring all covered entities to appoint a Chief Information Security Officer, otherwise known as a CISO. That can be either an employee of the company, which is probably not very practical or likely for most small to medium financial service firms. It could also probably maybe not even be practical for some larger firms. So one of the concessions that they made was they allow the financial service firm organization to hire a third-party service provider, someone such as Compass or someone like that, to serve in that role. The catch is you are also still, if you go that route, you are required to still appoint a senior level officer within the organization, an employee that still has oversight responsibilities, and really is kind of the main point of contact between and liaison between the CISO, assuming that you've outsourced that, and the internal organization. To try and make the regulation a little bit, I'll call it more palatable and practical, the way that they've implemented the requirements has been in what I'm calling a phased approach. And so it's not this big bang where you've got to have everything in place on a certain set date. It's really phased over a period of about 1.5 years, almost 2 years for some things, and we'll get into that in a little bit. But the goal there, again, I think, because as we'll talk about when we talk about the limited exemption, this really applies to a very broad set of organizations that fall under the compliance and regulation requirements of DFS. So speaking of those exemptions, so Section 500.19 specifically addresses exemptions, and there's some of the folks that, or some of the feedback we've heard is that some people sort of misunderstand this and think that if you meet any of these criteria that you're exempt from the entire regulation, and that is not true. You're only exempt from a subset of the regulation sections. So again, it only provides limited exemptions. And what that means is if you fall into one of these 3 categories, so if you have fewer than 10 employees, that includes independent contractors, or you have less than $5 million in gross annual revenues in each of the last 3 fiscal years from your New York business operations. So you've got to be able to carve that out and show that to an auditor that you meet that threshold, or you have less than $10 million in year-end total assets. So it's not that you have to have all 3 or 2 of the 3. If you meet any one of these criteria, because they use the word or, you are what we call, or what I'm calling, have a limited exemption. And so what that means is that if you meet those criteria above, you are exempt from 9 of the roughly 20 regulation sections, and we'll walk through what those are in a second. So here are the 9 sections that you're exempt from, and I think it makes sense. These are really kind of some of the larger, heavier lift items, if you will. and so we'll just kind of run through these quickly. So if you meet one of those exemption thresholds, which admittedly is a very low bar that most organizations may not meet, you're exempt from having that formal CISO that I mentioned earlier. You can still do all these things. It's just you're not required by law. The pen testing and vulnerability assessments, so those were required. You were required to annually perform a pen test, and then twice a year, semi-annually, perform vulnerability assessments. Audit trail, application security, you're required to, if you're not exempt, have in-house or cybersecurity personnel, which you can outsource. You can either have them in-house or use a third-party provider. Multi-factor authentication, so think two-factor authentication if you're familiar with that. Training and monitoring, encryption of MPI or non-public information, and then an incident response plan. I will say, though, that these are kind of very basic sort of security best practices items. So although they're not required by law or according to this regulation, these are all things that really just are kind of common sense, good things to do from a security standpoint. And so, yes, the law does not require, if you meet one of those three thresholds, you to do any of these things, but keep in mind, if you do have an incident, if you do have a data breach and you do have to do a notification to the state, they're probably going to come in and look at your policies and procedures and what activities have you done to prepare. And if you don't have a lot of these things in place, then you are, that's going to open up a whole other can of worms. So these are good things. There's a reason that they're in there, but they also give you kind of an out if you're too small to be able to kind of do this from a resource perspective. So some key deadlines. So March 1st, as we mentioned, we'll just kind of walk left to right. March 1st is when this regulation became effective. They didn't give a tremendous amount of time for companies to kind of prepare based off of the draft. This actually came out relatively fast. August 28th, which is almost right around the corner, that actually is when the 180-day transitional period ends. And so you have to have in place by that date your overarching cybersecurity program, which is, again, built and based off of that risk assessment. You have to have your cybersecurity policies in place. There's a list that they provide in the regulation. You have to have your CISO in place, whether it's a full-time employee or an outsourced third-party provider. You've got to have your access privileges defined and implemented and enforced from a system standpoint. Your cybersecurity personnel and intelligence, again, that's training, that's making sure that you've got the right set of expertise necessary to put all this in place and respond. You have to have your incident response plan in place, and then also your notices to the superintendent process. So basically the way that works is you have 72 hours from the time of a cybersecurity event occurring to formally notify the superintendent. And that all takes place through a portal that they're in the process of setting up. By September 27th, that's really kind of when your window closes for submitting your notice of exemption. So right now the portal is up, although it's not fully operational where you would submit that exemption notice. It's supposed to be online by August 28th as well, and then you basically have 30 days to submit that notice of exemption. And again, that is a limited exemption, keep in mind. By February 15th of next year, that is the time when you submit your first certification that you are fully compliant with everything that's required up until that point. So basically everything that's spelled out underneath the August 28th date, that all of that is in place and operational, and then there's some additional requirements that fall into place and are due by February 15th as well. March 1st, that's when the one-year transitional period ends, and so by then you have to have your first CISO report. So basically this is a report that's provided to the board, or if you don't have a board, your senior most officers, and it's kind of a state of the union, if you will, on the risks, threats, and really maturity, if you will, of your overarching cybersecurity program. You have to have completed your penetration testing, at least for that year, and vulnerability scanning. you have to have completed your risk assessment, which really practically speaking, you have to complete that a lot earlier because your cybersecurity program is developed based on that risk assessment. So even though it's not due till sort of that second phase, you really have to have performed that by the August 28th deadline, because again, that's what really feeds your cybersecurity program. Multi-factor authentication, you've got to have that implemented across all of your systems that contain NPI, and then you also have to have training and monitoring in place. Fast forward to September 3rd of 2018. That's when the 18-month transitional period ends. By then, you've got to have your audit trail, your application security. So if you do any kind of development in-house or externally, you've got to have processes in place to make sure that it's being done securely. You've got to have data retention policies clearly defined. Again, continuing that training and monitoring. And then by then, you also have to have all NPI, non-public information encrypted, or at least a process for that and the tools and mechanisms to do that. March 1st of 2019 is really when the phasing ends. And so by March 1st of 2019, you have to be fully compliant across all of the requirements. And so again, this is that phased approach that I mentioned earlier. Admittedly, for small to mid-sized organizations, this is a heavy lift. It's a lot of work that needs to be done. The good news is it doesn't all have to be done with in-house personnel. It can be done, you can use outsourced or what they call third-party security providers. Excuse me. So here's just a lot of the same information, but just sort of in a different kind of format. So you can see, again, they don't use the term, just sort of in the interest of disclosure, they do not anywhere in the regulation use the term phase. They do give you deadlines with dates, which is where these came from, but they don't call them phase, but just, we're project managers at heart, so that's kind of how we think of things. So you can see what's due by August 28th, which we talked about a bit. There's more detail in each of these sections if you were to pull the regulation, which we're happy to send a copy of afterwards if you're interested. So you can see, again, it's 4 phases. The last phase ends, as we previously mentioned, or I previously mentioned, March 1st of 2019. But it's really, again, kind of an incremental approach. And then it's not like this ends, so March 2nd of 2019, you really kind of go into just the normal cadence where you're just, doing all of these things. You're annually certifying, by February 15th of every year that you're fully compliant. And if you do have if you do have a security event or some type of a data breach, you have to notify them within 72 hours. They're probably going to send auditors on site to then validate, are you actually doing everything that you've claimed and that you're complying with up until that point. Some practical tips. So as I mentioned earlier, really it's a little backwards in my opinion, but the cybersecurity program is actually due prior to the risk assessment, but then they very specifically state that your risk assessment is what drives your cybersecurity program. So you really kind of have to move that to a sooner due date. Otherwise, you're going to wind up expending resources and doing things that you may not really need to be doing or want to be doing. One thing, and again, we've been talking to a number of organizations that are in the process of putting all of this in place and making sure that they're compliant. You can have 2 organizations that look very similar on paper, whether you want to look at it from an employee size perspective, a revenue, a locations, network infrastructure, but they can have very different risk assessments. And a lot of that is based on, everybody is invested differently in cybersecurity technology and infrastructure, and just from an IT perspective, some organizations have more mature policies and procedures in place. So maybe one organization has a pretty mature incident response plan. They do tabletop exercises, even some small organizations. And then there could be another organization that, again, on paper looks exactly the same, but they don't have, they don't do tabletop exercises, nor do they even have a draft of an incident response plan in place. And then ultimately, a lot of this has got to be driven by senior management. And so it's really somewhat incumbent also on and dependent on their level of knowledge just about cybersecurity in general, IT, and so we find organizations have a wide range. So some executives are very up to speed on this, and others are don't even, haven't even really read the regulation yet and don't really understand fully what they need to be doing. And so, again, those risk assessments are really important to make sure that you're using your resources and allocating your resources as optimally as you can, making sure that you comply. But really, at the end of the day, the spirit of the law is what you want to be doing is protecting your consumer data that they're entrusting you with. You also really want to understand your organization's unique threats and risks. And so you may be an organization that's in the same, so maybe you're in the mortgage loan business, but because of the third-party apps that you use, or maybe because you use third-party apps and the way that your network is architected, there may be threats that are unique to you or risks, inherent in the way that it's architected, and then the associated kind of security control options will be somewhat dependent on your environment and your architecture, and also your processes and the knowledge level of your people, and there's a lot of variables that kind of go into that. There also may be cases where you have security controls in place, but they may need to be adjusted to maybe better address or more completely address the risks and the threats that come out of that risk assessment. And again, those are things that you would not know unless you went through kind of a risk assessment and control mapping. So it's also highly likely, again, based on the conversations and work we've been having so far, it's highly likely that most organizations, somewhat regardless of size, are going to have to implement some level of new security controls to comply with this regulation and really to address threats and risks. So really risks are threats plus vulnerabilities. So if you look at the threats that are unique to your organization, you look at the vulnerabilities that lie within your organization, those all become risks that need to be managed. And so it's really important to understand what are those risks, how can they be remediated, and really understanding the different options. There's 50 different ways to achieve a lot of the same things. They all have wildly different costs or prices associated with it. Some are more complex, some are more simple. And if you don't really have a good grasp of what those options are, the pros and cons of each, then again, you may wind up making a decision. So maybe you make a decision that's compliant with the law, but that then sort of handcuffs or negatively affects or impacts your business, and you don't want that happening, obviously. You do want to get, these dates are not moving from anything we've seen, so those organizations that kind of wait until the last minute, the amount of work, the level of effort is not going to shrink over time. There's nothing magical about it, about that. So you really want to get started sooner than later, particularly with performing that risk assessment. So as I mentioned, the scope of work and what that entails is not going to get less as you get closer to that first deadline. It's really not going to change. It's just going to have to be fit into a compressed kind of window of time, which you want to try and avoid. It also, if you go that route and you kind of, what I'll call rush it, it's likely, and this is true in any decision that you make. If you make a rush decision based on limited facts, odds are you're going to make probably a poor decision or maybe not as good of a decision and not as thoughtful of a decision if you had given yourself a little bit more time. And it ultimately could mean that you've got to implement something that's more costly just from a time perspective. Something else to keep in mind, you're going to be living with this for a long, long time, so you really want to be thoughtful and diligent in your approach. This is something that's becoming more and more embraced by organizations, cybersecurity regulations, standards, laws. We're seeing other states that are looking to adopt the exact same type of program, and I think we will see that rolled out across a number of states over the next 12 months. And so again, this is something you're going to live with for a long time, so you really want to do it the right way out of the gate, not necessarily rush it just to make it, make a date. Although, admittedly, it's not like it's set in stone that you can't continue, you can't, modify it or adjust it as your business needs change over time, but you really don't want to, you don't want to expend energy and resources rushing to a solution quote just to make a date that then you're probably going to change, shortly thereafter. Again, just not any good use of resources. So that's all that we had. You can find more content. We share a lot of content related to both this regulation and other security best practices through a variety of social media. And I encourage you to subscribe to these, follow. We also have a podcast series out on iTunes and SoundCloud that also has depending on your preference, if you don't like to read, you can listen. Put it on next time you're traveling. So we've had a couple of questions come in throughout the course of the presentation, and I'll just take them in order. So the first question is, what are the recurring requirements for after the final March 2019 date? And so really the requirements there is you kind of get into a regular cadence. So if I jump back to this slide, which really shows all of the items. So again, the expectation is that these are the dates where these will be implemented by, but then the expectation is that you will continue these. So it's not like just because you had it in place as of that date that you can then sort of set it aside. It's that you really need to be kind of continuing to do these things. So, every year that CISO has to be working with the organization to create that annual report. Every year you need to be filing that letter of compliance, ongoing activities, auditing, those types of things. So those are all things that are required beyond that March date. Next question, can the appointed CISO be someone in the firm who isn't technical? So good question, and I apologize, I skipped over that earlier. So the language that they put in the regulation is that it has to be a qualified individual. They don't specify what qualified means. But sort of the industry kind of rule of thumb is that typically it's certification related. So it could be that they have to have a CISSP or something along those lines. CISA, CISM, those types of kind of internationally recognized certifications. They do not say that. They actually defer to, basically to the organization, I guess, to define that. But again, if an auditor comes in and it's, there's an office manager that all of a sudden now has an additional hat that he or she is wearing of CISO, probably not going to pass the qualification kind of red face test, if you will. They're probably going to have a bit of an issue with that. So what we would recommend from a qualified perspective, again, someone that has, advanced degrees, security-related certifications, that's really what they mean by qualified. I think that when they do an amendment of this, I think they will go a step further and really specify what that means. But for right now, they leave it up to the organization. Third question, could you describe the risk assessment process? So really the risk assessment process, if you think about, kind of from a threat modeling standpoint, it's taking a step back. It's looking at your organization, both from a technology standpoint, from a policy and procedure standpoint, and then from a, people or employee standpoint. And it's saying, okay, based on the industry you're in, the type of data that you handle, the threats that we know that are out there, which of those are the most relevant. And again, looking at your organization from a vulnerability standpoint. So vulnerabilities don't necessarily just mean technical vulnerabilities. It could be that you assess your organization and your employees don't really know anything about kind of basic good security hygiene or social media, safe web browsing, those types of things. That's a vulnerability, which a lot of times people don't think about. It could be that you're lacking certain policies, so like that incident response plan. Again, that's a vulnerability. So that risk assessment is taking those threats, marrying them to those vulnerabilities, and then prioritizing and kind of putting in context what those risks look like. So last question. Again, happy to answer any more. How do you think this regulation will affect other state standards? So good question. So a couple of weeks ago, there's an association for everything, and as you'll probably guess, there is a National Association of Insurance Commissioners. And so the superintendent of DFS actually spoke, I think it was early April, at their annual conference. And these are basically what the association is state or insurance commissioners from all of the states are represented, and it's kind of their annual meeting where they try and drive standardization, information sharing, best practices, those sort of things. And so the New York State superintendent, DFS superintendent, actually spoke at that and shared, very similar to what I'm doing here, kind of shared the different aspects of the regulation and why they did it, and what they're sort of planning. And what we learned during that annual conference was that pretty much every state's insurance commissioner, every state has a similar agency within their state government that has a very similar role to DFS, and that they are all in various stages of developing and rolling out a very similar sort of regulation. The superintendent for DFS was very strongly recommending that those states really kind of adopt from a standardization, sort of ease of understanding across state lines. There seemed to be a large appetite for other states to adopt what New York State has already done and kind of learn from their lessons, if you will. And we definitely see that happening. Again, I think it'll take, every state's going to be on its own kind of timeline, but I think over the next 12, maybe 18 months, you're going to see this, very similar, if not maybe identical, type of regulation rolled out really across the country. Because what's happened is the federal government, there's lots of standards and frameworks from a federal government perspective, but there really isn't a cybersecurity standard per se. Closest thing is probably within the United States. There's nonprofit, there's organizations that definitely have standards, but as far as sort of a law on the books that says you will do X, Y, and Z, it really does not exist unless you're in a regulated industry like healthcare or something like that. There it's very prescriptive. And so the states have really decided that they need to take it kind of upon themselves, and so I think that's why you're going to see the states take an even more active role than they already are. So something also to probably think about is, how, if you do business in other states, depending on how your organization is set up, you probably want to be looking at potentially implementing something very similar in those other states kind of proactively. So that's all the questions that we've had for today. Thanks very much for everybody's time. If you have any questions, by all means, feel free to reach out to us. Again, we share a lot of content through social media. This webinar was recorded, and so we're also able to and more than happy to share a link to it if you'd like to share it with anybody else within your organizations. So thanks, everybody. Have a good afternoon, and thanks again.